Eric kind of touched on that there's a delay in census data, and that's what our next panel will discuss. We have Rebecca Green and Suzanne Almeida. Rebecca is going to cover the census delay in related litigation. She teaches election law, legislative redistricting, and GIS, privacy law, and alternative dispute resolution at William & Mary Law School. Rebecca writes at the intersection of elections and privacy, most recently on the relationship between transparency and redistricting litigation. And Suzanne Almeida is going to cover work to be done before the census data arrives. As a redistricting and representative counsel, Suzanne is responsible for supporting state common cause organizations in their redistricting reform and census work through legal, legislative drafting and strategy, communications, and coalition assistance. She also works on state-based and national redistricting and census litigation. Before coming to Common Cause, she worked with the League of Women Voters of Pennsylvania and Pennsylvanians for Modern Courts. So welcome, Rebecca and Suzanne.
Great, thank you so much. I'm really happy to be here. It's been such an interesting session already. And looking forward to hearing from the other panelists. So I was asked to speak about the census delay and about differential privacy, and I'll try to cover those both within 10 minutes. So I've been teaching this class at William & Mary with Rob Rose, who is the director of the William & Mary Center for Geospatial Analysis. And I teach the law side and he teaches the computer side. And together we teach the students to use GIS to draw legally compliant districts in Virginia. We started by having students draw remedial districts for the Bethune Hill litigation. And we're really excited this fall to have a chance to use the 2020 data for the first time in class to draw US congressional districts. So from our perspective, the timing has worked out great because we can't start until the fall semester. So we've been able to time the class with what looks like when the data will be released. But of course, the delay has not been ideal for Virginia, especially since we're one of the two states that hold off-year elections. So I thought I'd just provide a little bit of background about what's going on with that. And then, as I say, I'll mention a few words about differential privacy. So I'm not sure I have much to add beyond what the commission has already discussed in its meetings, prior to today. In terms of what the timetable looks like, it's looking like the release will happen in September. Of course, there's litigation pushing for it to happen sooner. And ordinarily in decennial redistricting years in Virginia, delegate primaries are moved to August to accommodate the census data and getting new maps in place quickly. The Census Bureau has traditionally given Virginia data earlier than other states because it recognizes that we have this off-year election problem. But since the data is not likely to be released until September this year, of course, that fix is not possible. So the plan seems to be to run elections on existing maps in November. But so far as I'm aware, neither the Attorney General or the General Assembly have moved to secure that provision or secure a provision that would make those elections constitutional. The problem, which has sort of been mentioned earlier, is that districts have to be equally populated because of a US Supreme Court case from the 1960s called Baker versus Carr, which held that electing representatives from districts with different population violates the Equal Protection Clause of the Constitution. So what I guess I worry about in Virginia, or what we're potentially setting ourselves up for, is that whoever doesn't like the result of November's election could sue on this basis. They could argue that the districts were unconstitutional because they don't account for the population changes over the past decade. So I think there are three reasons why this could be a losing argument in court. First, we're dealing with an extraordinary and unprecedented circumstance where the census has been delayed due to litigation and a global pandemic. And the court may take this into account when judging equal population requirements. Second, at some level, we are always operating at a level of fiction when it comes to equal population. We've held elections in, for example, 2019 and 2020 based on districts that obviously aren't in reality equally populated. So perhaps that could help a court sort of understand what's happening this year. And then third and finally, I think Virginia arguably is picking the best and least disruptive of multiple bad options if it runs the November elections on existing maps, just because the data simply isn't available to do it right. So the timing has definitely thrown some uncertainty into Virginia's elections, but I wanted to stress what I've heard discussed in the commission meetings thus far, and that I agree with very much, which is that for purposes of the commission's work and that of local redistricting officials, this delay is a very good thing. It gives you time to prepare and learn. It gives you time to lay the groundwork to create responsive districts. And it gives you time to gather public input about where the line should go. So I understand that it's not perfect to have uncertainty injected into the process in terms of the timing of the data, but I do think I for one anyway am happy just to have a little bit more time to prepare, especially since Virginia has changed its process this year. All right, so that's kind of the easy one. The hard thing to talk about, I think, that it's a little more complicated is what's called differential privacy. So I'm going to try to explain what it is and what the impacts are potentially in Virginia. So the Census Bureau is bound by federal law, this is Title 13 of the US Code, to ensure that no information collected by the Bureau through the census process is revealed about any specific individual or household for 72 years. This is Section 9 of Title 13. So to ensure that nobody can figure out who is who when the data is released, the Census Bureau has historically engaged in a process of what's referred to as disclosure avoidance. That's a process of making changes to the data for purposes of protecting a respondent's privacy and confidentiality in published statistics. And that means that in the past, the raw data has never been the same as the reported data because there have been sort of injections to protect people's privacy. In previous cycles, there was no effect on the total population at the block level, and only a minimal effect on totals for specific characteristics within that geographic area. So the impact on data accuracy in the past was generally not seen as significant. For the 2020 census, the Bureau made an internal decision that the previous approaches to dealing with this confidentiality problem are insufficient to meet its Title 13 obligations because of technological advance. There's growing computing power, there are advances in mathematics, and there's easy access to large public databases that are gonna the idea here is that given all this modern technological ability, census data can be too easily reverse engineered to figure out who people are. And so the feeling was that this time around, for the first time in US history, something different needed to be done to protect census respondents' privacy. What the Bureau has done to address this concern is to adopt a new disclosure avoidance strategy that's called differential privacy. And I am neither a computer scientist or a mathematician, so I'm afraid I'm going to keep it general in terms of how I describe what's being done. But essentially, differential privacy is a mathematical method that adds what's referred to as statistical noise to published tables in a way that protects each respondent's identity. And the idea is essentially to make it impossible to link data to a specific person. And the Bureau's proposal so far, I think they're going to be issuing more information and guidance in June, but so far what we know is that 3 data points will be kept invariant, meaning they won't be altered with the differential privacy process. The first is total state population will not change. So for purposes of apportionment, that's obviously for the US Congress, that's very relevant. Also, the total number of housing units in each census block will not be changed or altered in any way. And finally, the number and type of each group quarters unit in each census block will not be changed. In other words, the housing type won't be changed. But this time around, the proposal is that differential privacy will mean that, except at the state level, population and voting age population will not be reported as enumerated. So that means that, for example, race and ethnicity data are likely to be farther from the as enumerated data than it had been in past decades. The Bureau thinks that differential privacy will allow it to use math and computers to precisely control the amount of statistical noise that's added using these formulas. But the concern, of course, is that the Bureau didn't adequately think through the impact of differential privacy on Equipopulation or Voting Rights Act compliance. So the Bureau released a series of demonstration products where they took their idea of differential privacy and they applied it to the 2010 data to sort of show how it worked. And there have been a lot of groups who've studied that and kind of pointed out some concerns, particularly with respect to Equipopulation and Voting Rights Act compliance. So on the Equipopulation front, studies of those demonstration products showed that at both the US congressional and state legislative district levels, there are concerns with whether differential privacy will meet the required Equipopulation thresholds, right? Which is no deviation for US congressional districts and 10% total population deviation for state legislative districts. In terms of Voting Rights Act compliance, the picture is even more concerning from my perspective. The demonstration products were, they sort of showed that there are really big concerns about whether minority communities would be reflected accurately enough to draw district lines with the specificity that's required to comply with the Voting Rights Act. So the Bureau has indicated, as I said, that it will release more information in June. Meanwhile, the state of Alabama and a few others have sued the Census Bureau. They're challenging both the delay and also the decision to use differential privacy. They're arguing that it's a violation of federal law that requires the Secretary of Commerce to report each state's accurate tabulation of population for subparts of each state for purposes of redistricting. That's also in Title 13, Section 141C. And they've essentially argued that the Department of Commerce has announced that it will instead provide states purposely flawed population tabulations at the lower levels. So Alabama is asking the court, a federal court, to declare that the delay in the use of differential privacy violates federal law. It's not quite clear what will happen with this suit. I think there's a possibility that the court could refuse to enter the fray on the grounds that this is a political question that courts shouldn't answer. That seems sort of unlikely to me, given how involved courts are in policing Equipopulation and the Voting Rights Act. Or it's also possible that as calls rise to address this, perhaps the Department of Justice will get involved. I know that there's been sort of a bipartisan effort underway to address these concerns. It's possible that the DOJ will step in and require that there be a fix to this. If you're curious for more information about this, one of the, I think, leaders in thinking about this, at least from a redistricting perspective, has been the National Conference of State Legislatures. And I will put in chat, I don't know how to get it to everyone. I'll give it to Liz and maybe she can circulate it to everyone. The National Conference of State Legislatures has a great website that walks through the basics of differential privacy and explains kind of for the layperson what it is, and also has links to resources. They've also written a letter to the Department of Commerce requesting that this be addressed urgently because of concerns about Equipopulation and Voting Rights Act compliance. So it's a very live question. I'm not sure how it will be resolved, but I hope this helps you understand sort of what the issue is and where things are at the moment. So I'll stop there.
Thank you so much, Professor Green. Suzanne?
Great, thank you so much. And I am going to share my screen. Give me just a second to get it up. So first of all, thank you so much for having me. And I want to talk briefly today about how we can use kind of this extra time, right? Professor Green really talked about some of the challenges that we're going to see given the change in the census timeline of when they're going to release the redistricting data. But I do think that just as she was talking about kind of the benefit for her students, there's also benefits for commissioners, both on the local level and on the state level, as well as for advocates. So the first part that I'm going to suggest is that we should take this time to really craft the process by which we will draw maps, by which we will hold hearings, all of the kind of the pieces that go into a truly transparent, open, accessible, inclusive process, and to really take this time to craft that in community with partners and stakeholders, right? Typically, we would have all of this being done in a very condensed timeline. And for Virginia in particular, that's a challenge because you all have not been through this process before with the Redistricting Commission. So this extra time really allows you to kind of have the conversations that I know you've been having through your open meetings and your hearings about what stakeholders, what community members, what advocates and experts are looking for from a redistricting process, and then working together to bring that process together. Obviously, we know, and as someone who works with Common Cause, one of my big priorities is making sure that residents are educated and engaged in the process, and that communities are included in community testimony should be prioritized, right? So a lot of the work that can be done is going to be not just kind of creating the internal processes, as well as kind of making sure that you are advertising all of the pieces for your commission or your decision making in a very public way, but also thinking really carefully about how we can engage the people who live in Virginia and what we can do to make sure that they are educated about the process and then engaged. So this is the second, brings me to my second point, which is really the outreach part. And I think that that is the biggest silver lining in the new census data delivery timeline, is that we now have time for really robust community education, coalition building, other preparation, having the hearings for community of interest or just descriptions of communities, right? So one of the things that I think is really important to point out, and what we talk about a lot when we're working with grassroots organizations, is that a community of interest is just a fact, right? It does not rely on census data to be true or false. And once those community of interests are pulled together, whether it's a map, whether it's by testimony, whether it's in kind of a broader conversation or a smaller, more intimate conversation, whether it's a written description, what those can be done is those can be used as building blocks that will then be used with the census data when it's released, either using the legacy release in the middle of August or the actual kind of fully tabulated, and I'm calling it the pretty version, that will come out the end of September. To actually draw the district maps, right? So we don't need, when we talk about communities of interest or talking about community mapping, right? We're talking about three main things with our advocates. And I think it's important that commissioners, both at the local level and at the state level, or other map makers, really understand kind of how some advocates are approaching this. So one is we're looking for a cohesive culture or characteristics to the community. So kind of we're going to dig more deeply into this, so I'm going to go through it really quickly. So culture. The second one is, what are the concerns of the community? What are the things that they hold in common? And the third, and the final one, is counts, right? So what is the data that can tell a story? And that third one is where maybe census data comes into play. Maybe it's American Community Survey data, which is, again, more characteristic based, not as precise as the Census Bureau decennial population data, but also really used to paint the full picture. And then finally, I would really encourage the commission, map makers, at whatever level, to think about using this time to have lots and lots of hearings about not only where communities live, what concerns communities have, and why they need to be kept together or combined with other communities, or where lines should go, but also to really kind of hold a public process about combining the community of interest data and the census data, and kind of all of those steps, right? So we know that it's really important every step of the way to be as open and transparent as possible. We also know, and this is particularly pertinent in states like Virginia and Michigan and Colorado, who are having their first commission process this year, that there is a huge education gap. The folks who are most likely to be engaged and educated on the issue are people who look like me and have a similar educated background, right? So white, I live in a city, I have a law degree, I spend my life doing politics, right? These are important voices, but these are not the only voices, and these are the voices that are typically centered in the redistricting process anyway. So this extra time can really be used to reach out to those communities who don't get in the process quite as often. So the next part that I really want to highlight is that I think it's important and often overlooked that this time could be used to really build the team that is the commission or the map makers if it's a local jurisdiction, right? So you all are going to be called on to make some incredibly difficult, incredibly fraught decisions. And, you know, it is hard work, it's long hours, it's a lot of information coming at you really quickly. And I think one of the keys to doing that successfully is working on how you're going to operate as a team. And that often means getting to know each other as humans. I know that in Virginia, the Redistricting Commission is partially legislators, all of whom may have worked together in greater or lesser extent in the past, but there's also a citizen component, right? And so making sure that you all are interacting regularly, and maybe this, you know, in the age of Zoom, looks like Zoom happy hours, looks like, you know, times where you are meeting, not discussing commission business, right? Because we want to preserve the transparency of the process, but really highlighting kind of the humanness, figuring out how you all are going to work together moving forward to make sure that when you get to those thorny decisions, when you get to those inevitable disagreements, because that's the way this process works, you will be able to kind of work together, rely on each other's decision making, trust each other, and come to conclusions that work for everyone. And then finally, I just want to highlight, because I know we have kind of a mix of folks on our call today, that for communities and for grassroots organizations, we are also really using this time to educate folks, to make sure people understand the process. Common Cause, League of Women Voters, and a number of other organizations are part of a national coalition called Charge, where we're holding national trainings to educate folks, not specifically about the redistricting process in any one state, but really just the basics. What is redistricting? How does it impact you? How do you get involved, regardless of your state, regardless of whether you are looking to testify for a commission or draw community mapping. And again, a lot of this is going to be gone over in more detail later on today. So I'm not going to spend a lot of time, but I do want to kind of highlight, and with this I will end, that this extra time is, while it does present some logistical challenges, and I do want to acknowledge that this is actually, I think, a benefit, a net benefit, particularly in states like Virginia, who are going through a new redistricting process for the first time, because it allows you the space, it allows you the time to really dig in and co-create with partners, with stakeholders, a process, gather information, educate yourselves, and really move the whole thing forward. So with that, I will stop, and I will stop sharing my screen.